I'm using StreamYard, and it's not exactly connected to my Instagram yet. So anyways, I think I'm now live on Facebook and Instagram. Hopefully you all can see everything okay. I'm not going to be on here long, but I did promise to do an update on yesterday's temporary restraining order hearing. I want to first say thank you again, heartfelt thank you to so many of you. Definitely One Mom's Battle and that community that definitely was posting the court watch request, definitely National Safe Parents Organization also as well. And then many of you just independently sharing and getting the word out to be able to have people show up and be there in Collin County for that TRO hearing, which is the first action that the family courts took after my illegal and unlawful arrest and imprisonment in Oklahoma at the hands of the Colony Police Department officers that took intentional and knowing fraudulent steps to basically be able to silence me and take my daughter right back into abuse and neglect, thinking that that would settle things. But again, you all spoke up. And so as the arrest did occur, I had mentioned in one of my lives leading up to the TRO date that I could see why the judge would sign it. Ex parte is not evidentiary. It was not some big thing where they needed to prove their facts to be able to get the temporary restraining order. The basis is under penalty of perjury. Whatever they are alleging is an emergency. The courts can grant a temporary ex parte order that gives up to 14 days before the court by law has to hold a hearing and allow the party who now has been restricted from their child the opportunity to appear in court to defend themselves, to dissolve it, and to address the allegations against them. And so that was set to happen yesterday, which was December 5th at 9 a.m. in Collin County. We did show up for that, and we got there and realized that there was a visiting retired judge that was there in the courtroom. Instantly, Dad's attorney was not comfortable with that and mentioned that she would definitely make an objection to having the case heard before a visiting judge that was not our new custody judge, because of course our case was picked along with, I think, about almost 1,300 others to go into the newly formed 494th District Court. This was a court that was just created by Governor Greg Abbott end of September. Brand new judge was appointed, Judge Catherine Pruitt, apparently very seasoned judge, to be able to take this court and caseload on. They mentioned in just news reports that this is a court that was designed to really focus on more of what they call complex or high conflict, very contentious, complicated family law matters. And that was the design and the purpose for this court. And even though we had a new judge as of March, when I had a full day trial, pro se, Dad was pro se, judge heard us both out since 2016 and definitely restored my parent-child relationship to my daughter. As we'd had quite a journey in that courtroom from end of March, and then of course her being ordered exclusively into my custody, care, and control by actually 3 judges by way of restraining and protective orders that kept being issued and extended. 3 different judges out of both our custody court and the auxiliary court kept ruling on that, and she was with me from mid-April all the way till August 12th. With those 3 judges, now, yes, we were assigned, and now it's a 4th custody judge. The reality is, in my daughter's case, she's 10 and a half. There have been no less than 15 judges that have touched this case in some way, shape, form, or fashion, meaning they've heard it, they've transferred it, they have done any number of different things. And so her argument actually made sense. And I kind of had the same feeling of, oh no, because every time a new judge gets involved, you now have to kind of catch up the history of all the dynamics, and TROs are 20 minutes aside. So that is a lot of work to do, to have to go back and lay the groundwork and the foundation of what has been going on in this case since 2015 to how did we get here today, to have time to put all that together in perfect packaging, 20 minutes aside. So actually was in agreement with counsel that that was going to be a little bit difficult. And so we were going to try to reach an agreement, what they call a Rule 11 agreement. It's basically settlement agreement. If we had done that, that would have basically dissolved the TRO, which technically wasn't fully enforceable because it had not been served yet. You know, when there's scheduling of hearings and things of that nature, if you were pro se, meaning acting as your own attorney, you do need to cooperate, right? You need to be able to, when the courts or opposing counsel email and they're trying to set a date on the calendar, you need to, you know, communicate and say, yes, I'm available this date and time, not this date and time. So of course I was agreeing to do that. And I also made it clear I did not want the TRO being heard to go past my 14 days because they've already, in orchestrating this false arrest and imprisonment, basically wiped out our 2 visitations in November. And I was supposed to be able to pick her up today after school. And so scheduling it yesterday was me saying, look, I'll cooperate in setting a date, but I don't want it to go past my 14 days. And so all of that said, I agreed that, you know, that's going to be difficult. Let's try to see if we can reach an agreement. They were basically wanting me to agree that I won't have any unsupervised access to my daughter. And yes, you can pay a supervisor. We were spending some time kind of looking at available possible supervisors, charging anywhere from 40 to 60 to, you know, there's one, I think it was a 2-hour minimum of $275. And, you know, while I was willing to do that, there was a part of me thinking it shouldn't be in place to begin with. And, you know, I asked, hey, is dad willing to pay half? Of course not. You know, why am I necessarily agreeing to pay money? And I couldn't get even confirmation that there were supervisors available. I did call, I did try, because I wanted to make sure if I make this agreement that I'm going to be able to access my daughter, and we just have to wait till the next date. They said that the soonest court date that the new court had available was January 26th, because there are also petitions, I should say, from me and from now dad to modify the parent-child relationship. And they said our soonest date that we could get on the calendar was January 26th. So we're talking about missing all of December, Christmas together. We have already been denied how many Christmases? 8 Christmases. My daughter's 10 and a half. 9 Thanksgivings. 8 New Year's. Her birthdays. 8 out of 10. 8 out of 10 Mother's Days. All summers except for this year, right after basically 2016. I think I was doing the math earlier. And again, this is not that I've ever been deemed unfit. This is not CPS has ever, you know, made a ruling that mom can't have her child. There's no drugs, no alcohol, no abuse, no neglect, no family violence. So none of that. But the 3,916 days that my daughter's been alive, 2,964 of those have been with dad, including his actual interference of child custody, him actually being in contempt of just about every one of my rights, him recently turning her over only under much protest after my son passed, and he prohibited them from being reunited Easter Sunday, and then my son passed 4 days later. And so, you know, when he talks about the fact that he lost October 21st through October 31st, and then technically till November 6th, because I was following medical advice to have her treated, and now he's so horribly damaged, that's just not what the numbers show. That's not what the facts show. And the same police department that went after me, they have refused literally 2503 interference with child custody offense reports against dad. They have in the courts not moved forward with enforcement. And basically he's allowed to be in contempt and deny our parent-child relationship. But when I'm actually abiding by Texas and Oklahoma law and cooperating with Texas police and Oklahoma and Texas CPS, I get put in jail. So it's just not a good situation. And while, again, I was being cordial and workable the best that we could, opposing counsel said that basically she was going to object to the judge that was there. They said there would be another judge that would then step in. She said she'd object to that judge. And then the regional judge, which is actually over more than just Colin, I said if she objected to both of those judges, then that judge would actually hear the case. But either way, the case needs to be heard today. And so at some point while I was trying to get a hold of a supervisor, she remembered that she hasn't met due process and had me personally served. And so had a process server give me the papers, which is fine. I had told her for a long time, really since she got on the case, hey, don't need my address, don't need to come to Oklahoma. All you got to do is arrange service. I will meet your process server, may possibly sign a waiver on some things. And so as I got served, then when the judge called us back in, he was able to basically hear her state. Now we have a different reason we can't move forward, which is I just served her. And so she gets at least 3 days. We can't hear it today. But because of the 14-day requirement, instead of them waiting till January 26th, by law, it requires the court to hear it within 14 days. And so we're able to agree on the 11th. So it has been reset to December 11th, 9 a.m. And then today, although I'm not going to give a whole lot of details, today we did get an email because that was another complaint that opposing counsel had, which is if it wasn't going to be our custody judge, we had a right to be notified before we showed up that it was going to be a visiting judge, a non-elected judge. She felt like as an attorney that was something that they should have told us and they didn't. And so right before, no, actually after the courts closed today, we got an email that did notify us that the judge is going to be out and we will have a visiting judge. They gave us that judge's name. It was one of the judges that would have heard it yesterday. And so we will not be having Judge Catherine Pruitt hear this TRO. It will be another judge. Opposing counsel has said this particular judge is out of Dallas. She seems to know her. And so that's what's happening. That is the update. So nothing really moved forward in terms of an actual evidentiary hearing on what's going to happen. Is it going to be put in place as a permanent injunction? Is it going to be dissolved? Definitely not getting into my legal arguments online, but I'm also not concerned. So it was good to be able to, be cordial with opposing counsel in the court and agree on another date. And so that is the basis of where we are. And of course, I'm missing yet another weekend. My daughter is missing yet another weekend with her mother and maternal side. And I'll leave it at that. But we will have a new court date in the 494th District Court. It will not be Judge Catherine Pruitt, but it will be first floor of the Collin County Courthouse, 9 a.m., December 11th, which is next Wednesday. And so definitely would appreciate any and all of your support. If you want to show up and be there in person, definitely love to have you all there. They are not offering any Zoom options at this time. And so definitely that was something I checked into because I now have some experts that have come forward to offer their services. Definitely for those of you that have been supporting, do the GoFundMe so that we can get to a place of reaching the goal to be able to obtain counsel. Definitely want to still continue to attempt to do that. It'd be great to go into the hearing with counsel, but I think we're, still maybe about a third of the way or so from the goal. And so if not, I'm definitely studying and preparing for the hearing on Wednesday and just going to move forward one step at a time. So that is the update. Don't want to take too much longer or get into too many more details, but do want to say I really appreciate, again, all of you staying watchful, right? Staying available and continuing to walk through this journey as, yes, I work to get Mariah safe with Mom Marlena. That's me. Love my baby girl, want her safe, and going to continue to move forward legally, lawfully, safely, and appropriately to pursue everything I can to make that happen. So it is Friday night. I'm sorry that I'm just now doing this live. When I got home from court yesterday, just very exhausted. I turned in probably about 6 or 7 and didn't wake up till about 1:30 in the morning. And it just really takes a lot out of you if you're pro se and dealing with this level of stress surrounding your child, all the dynamics. Thank you so much. I see your, God bless you, Mom. I appreciate you. Thank you. So it has been it's been a journey. But I wanted to make sure, as I did post, that I would go live and give this update, that I did that before I went to sleep tonight. And time you're watching this, thank you for, again, continuing to be amazing support. I really appreciate it. It really means everything. And I will keep you all posted, and of course hope to see some of you in Collin County on Wednesday. With that, I hope you all have a great weekend, and I look forward to talking with you soon. Take care. Bye.